On behalf of the Institute of Economic Affairs, it is my great pleasure to welcome you to our conversation today on freedom of expression and freedom of the media under the Constitution of Kenya. So my name is Jacqueline Kagume, and I'm very delighted to be moderating today's conversation that is convened by the Constitution, Law, and Economy Program of the IEA. For those of you who are attending an IEA meeting for the first time, the IEA is a public policy think tank, and as part of our objectives, we seek to advance informed and truthful discourse on public affairs, and also to promote economic and political freedoms. Among our other objectives, those are the two that have necessitated our convening of the discussion that we are having today. So the IEA has six broad program areas. As I mentioned, the CLE program is convening our discussion today, and I work in the Law and Economy program together with my colleague Leo, who you'll be hearing from later. But we also have different streams of work around budgets, and that's under our public finance management program, economic regulation, international trade and development, futures and foresight, and popular economics. So in a nutshell, that's the institution that you are engaging with. And that said, we go now to the background for our discussion today. So I think for most of you, it must be evident why we are having if any of you, for all of you who have been in Kenya recently, or for anyone who's been following the developments in Kenya recently, you must all be aware that on the anniversary of the June 25th protests, we had the Communications Authority of Kenya issue a directive to all media houses, all broadcast media houses, to cease live coverage of the demonstrations that were happening on that day. So the authority basically cited a few articles of the Constitution, trying to justify why they issued that specific directive, specifically Article 33, 2 of the Constitution, as well as Article 34. And that's in addition to Section 46I of the Kenya Information and Communications Act. So they stated that the live protests were in violation of the justification that they provided was that the live broadcast was in violations of the exemptions that are provided in those particular articles that we will interrogate in a couple of minutes. So this directive was obviously contested by the Law Society, amongst other groups, and they obtained conservatory orders suspending it, and Justice Mwita also actually suspended the issue of any other similar directive until the petition that has been lodged is heard and determined. So that was the first issue that was contested. And then I think just yesterday, most of you may have seen the Cabinet Secretary for ICT, who appeared before a parliamentary committee on delegated legislation, both responding to questions around the directive itself that had been issued, but also trying to defend a new set of regulations that they're seeking to introduce under the Media Council of Kenya Act. So many people who've had a chance to look at the regulations interpret them as appearing to curtail media freedoms even further. And if you watch that discussion, the members of parliament actually warned the CS as much. And so basically this situation and the recent developments has altogether generated a lot of debate over the scope of state power in regulating speech and in regulating media and the functions of the media. So at the IEA, and specifically if I speak for the CLE program, we believe that freedom of expression, and particularly freedom of the media, are at their very core, they are fundamentally economic freedoms. And both of these are prerequisites to any functioning open economy. So we were very interested in breaking down this issue further, trying to understand the logic of the authority, trying to understand the violations that are very apparent to most of us. And so we called for this discussion to be able to share a few presentations, listen to some expert views, and also to hear from you in terms of what you think, your ideas basically, and the views that you have on these developments. So we have, for that reason, we have a three-part conversation today, and we have three main speakers. So to begin with, we'll start with providing a context in terms of the state of play, just the current state of economic freedoms in Kenya. And this will be done by my colleague, Leo Kemboi. So as the CLE program, we've been tracking the Index of Economic Freedom, among also implementation of the Constitution. And so our views are supported partly by this evidence, and Leo will basically set the stage for this discussion in about 15 minutes. Then secondly, we are very privileged to be joined by an expert who will be interrogating the legal and constitutional prescriptions around the freedom of expression in the media, and specifically in terms of the limits of state power, trying to explain to us where legitimate state regulation ends. And this second speaker is Mr. Seku Owino. Seku is the head of legal at the Nation Media Group, and we're very glad that he's able to join us for this. And then lastly, to close our discussion, we will look at how this connects to economic freedoms and economic progress, basically to try and understand why safeguarding these freedoms is useful both for advancing liberty and advancing prosperity. And this last part of the presentation will be done by the IEA CEO, who is Mr. Kwame Owino. Kwame will close the discussion for us. So I should have added that Seku will take about 35 minutes, and then we'll have Kwame close in about 10 minutes. So in the meantime, if you have any questions, because we know that this is a very topical issue, please feel free to use the chat box on this platform. And we will also allow you during the plenary session to ask the questions that you have verbally. So that said, I welcome Leo. Leo, please go ahead.
The framing of this discussion is that while these questions relate to expression, freedom of expression, and the freedom of media, largely the common narrative that we hear in Kenya is that these things don't matter. The focus should be on the economy. And now I want to bring the economic perspective, while Seku will provide the constitution and legal perspective, why these things, and especially the freedom of expression and the freedom of media, are important to economic society, to free us, to making these societies freer and economically viable. But there is an economic reasoning why freedom of expression and freedom of the media is important. So first, we want to give a perspective on the 2010 Constitution. A constitution is always a set of, it's a charter. And given that it's a charter, we, in the economics literature, we have what we call institutions. And when we call it, we refer to institutions in the economics literature, we actually refer to formal rules, norms, and convention that shape human behavior and interactions within the economy. Now, so at the IEA, we've coined this term that we say institutions of the Constitution of Kenya 2010. And largely, they have principles that actually met what the Constitution of Kenya 2010, what it is today. And and this for us, we give a distinction that it influences how individuals and organizations make decisions, allocate resources, and also engage in economic activities. Remember, a Constitution 2010 is a product of the struggle of more than 50 years that to have that expansive Bill of Rights, doctrine of separation of powers. And part of the problem where economic freedoms in Kenya were a big challenge, especially during the one-party state, after independence, the one-party state, and also the fight towards multi-party, was the way the media and the way freedom was controlled. Remember, people in the 1980s, Mwakilishi, people who had what they call subversive material and the others. Now, in the Constitution, the Constitution brought those two things and distinguished them as two different rights. And I'll leave that to Seku to expound actually why the Constitution made, why it was done on the same, done on the same. Now, those two rights form part of economic freedom. And economic freedom is the individual's fundamental right to control your own labor and property. And that the few key features of economically free societies are people are free to work, produce, consume, and invest. I'll detail subsequently why freedom of the media and freedom of expression are important for that. Labor and economically free societies also, labor, capital, and goods, and know-how. Know-how is actually, economists consider technology, which is know-how, as and those are required to move freely without restrictions. The government is supposed to limit interference, and that's why the Constitution, just like many other constitutions across the world, and they are acting to protect individual liberty and maintain order. Remember, in a constitutional framework, the state has monopoly of violence. And when it comes to civil liberties, constitutions actually are made to constrain are meant to constrain the power of the state, that monopoly and violence. And then when you look at the data, when you look at the Global Innovation Index, whether it's the average GDP in purchasing power parity, you see that happens in economically free societies. And even if you look at poverty intensity, the last chart on the other side, you still see similar, that evidence points that where the more freer societies are, the more economically vibrant and that they are. Now, freedom of expression as economic freedoms. Remember that freedom of expression, free flow of ideas and access to of information. The state should not determine essentially what is idea, what idea is bad, what idea is good. That is a marketplace phenomenon. Like markets determine that. Individuals, how they can share ideas, challenge norms, create new solutions for whichever industry. And this is only done, that is a market participation and information. Access of information helps people such as consumers, investors, and business owners make informed economic decisions. Actually, in the markets where people innovate, you innovate because you are solving asymmetry. You don't know something, you're able to research, bring those ideas forward. So that's the essence of freedom of expression. On the other side, freedom of the media as an economic freedom. So, for example, when KNBS releases data, it's just data, but interpretation is what happens out, whether in a university, through an academic journal, or whether through commentating in a media station. That kind of, so a free media ensures unbiased reporting around economy, prices, jobs, and investments. It empowers citizens to make economic decisions, which are essential for free market. The second part, and I think this is the reason why people wanted the media to be given that constitutional right, is that there is a problem, the problem of governance. Investigative journalism exposes corruption and misuse of public funds, and that helps to protect economic institutions. The viability of a public finance management system, it can only be evaluated by independent actors, including the fourth estate. Economic opportunity and innovation, people allow entrepreneurship. That right of entrepreneurship in those areas, advertising, journalism, tech, and digital platforms. And when we think about the media, and CoK will speak to it, it's not just the big, what we call the big media. It's everything from your own TikTok vlog all the way to your own blog on WordPress. That's an important element that people need to understand. Public participation in economic debate. That I think is self-evident. My last slide. When we looked at there's data published, we wanted to give a sense and look at data published by external actors. One of them is this, what we call the Freedom in the World, published by the Freedom House. If you look at political rights and civil liberties, Kenya is considered what is called partly free. And even if you look at one of the subsets of that score is whether there are free and independent media. You look at 2 out of 4. And that gives a sense that part of that right is actually still a major something that is still under progress. So as I end, people need to understand that the way markets develop, a larger part of it has to do with information. And therefore, it's important that those constitutional rights, the framing, and CoK will explain why that framing for Kenya in the constitution and other case laws is important, because people think that focus on the economy, you can do anything to civil liberties, you can do anything to, but that is not that's a wrong thesis. And that's why we wanted to provide this. So Jackie, back to you.
Leo's has provided basically a sort of overall background with regards to the two freedoms and why we consider them to be fundamentally economic freedom. So at this stage, I'd like now to invite CoK to make the presentation on basically the limits of state power in terms of these two freedoms. So CoK, you're very welcome.
Thank you, Jackie, and Leo for that. I'll start by just trying to explain an important part of history, as Leo said, which is important. If you look at okay, that's the general overview. Thank you, Leo. I'll try and let's start there at that first slide 3.
Leo, please go back.
The essence.
Okay, sorry.
I'm fine. I'm okay. Thank you. Before I go into this, the essence of the media, freedom of the media, I would want to first start by giving a slight historical, whatever, on the context of in which 2010 Constitution, what it really changed regarding the Bill of Rights. At independence, the view was taken that we needed to have economic development driven through the state, okay, and then everything else would have to take a backseat. As a result of that, if you read our constitution that we retired in 2010, that's the Act number 5 of 1969, drawn from independence. The thinking around human rights was essentially civil and political rights. Okay? You did not have any economic or social or cultural rights. Now, the distinction was that there was a category of rights that was superior to the other, and that civil and political rights would be constitutionally protected, the others would be granted through the state, and therefore would take a lower rung on that, and that therefore would be called the second generation of human rights. Now that came with its own challenges, and we have 50 years to tell us that that was incorrect. And so if you read the philosophy of governments then, and that's not just in Kenya, but mostly in Africa, was that, look, let's chase economic empowerment and leave human rights alone for the time being. So as a result of that, because these economic rights were not guaranteed in the constitution, and then they said the economic and political rights, give them a backseat as we pursue economic freedoms, there was hardly any freedom. It was just authoritarianism and oppression. Now it looks to me that, or rather it's evident that with the 2010 constitution, at least the people who went to the referendum, Kenyans rejected that theory around rights. And they said human rights are human rights, and they all come in the same Bill of Rights, and none takes priority over the other. So that what we say here, therefore, is that if you look at the Bill of Rights, rights are to be looked at all as human rights to which people are entitled. Yes, there's a clause there that says that some of them will be enjoyed progressively, but that doesn't mean, and there's no reading there that would suggest that therefore there's a category of rights that precedes the others. So that is how it needs to be understood. The second thing that was done, now especially with regard to this, was that therefore you realize that our Bill of Rights as it sits today is much longer than the previous one in the previous constitution. And that too was also deliberate in terms of trying to specify as much of them as possible so that they're not left to chance, or they're not left to being thought of as a gift from the state, but that the people who are affirming them. So that thinking, if you look at it, particularly with regard to freedom of the media, the previous section 79 of the other constitution mixed freedom of the media and freedom of expression. They were taken as one right. And there also emerged a big problem. So as we speak here, let's talk about freedom of the media. What, if you look at the constitution at Article 34, is really the essence of the freedom of the media? That article, you realize, comes after, in terms of just serial numbering, it comes after Article 32, which is the right, which recognizes the right to opinion, conscience, and belief, and the right to express those. And then it goes to 33, which then now talks about freedom of expression, which then says that any idea that you have, any information that you wish to convey, you have a right to express it by whatever means of expression available. Then it gives the media a platform in Article 34, which then recognizes that the media is simply the platform through which ideas and opinions and expressions are made. So it provides a platform for vocalizing it, if you could put it that way, or for projecting it wider than beyond the person from whom it is being done. And if you look at 34, Article 34 is a very interesting one. I always say that it talks about the right to a platform, and it talks about in it, Leo, let's go to slide 2, the next slide. It talks about a guarantee. Okay, it is the only right which talks about a guarantee. It says that freedom of the media is guaranteed, and then it says the state shall not interfere with it. So basically, it's trying to tell the state that when it comes to the platform through which information is being conveyed, you have no role in it. Leave it specifically. And it says that specifically the state should not control media and or seek to regulate it. When it talks about 34.3, where it talks about regulation, it then states that when it comes to regulation, you shall not regulate it except through an independent body, a body independent of government control again. That too is important, because then it's trying to say, leave this thing, it's confirming that the state has no role in managing the platforms through which people exchange ideas. And that 34 talks about independence of all types of media. in all time, in the sense. So it just doesn't have to be broadcast, it doesn't have to be whatever. And here you can see that these people are even thinking, prospecting into the future, thinking whatever other kind of media will come up, we do not want the state having its hand on how information flow within the society travels or is projected. And that's why it says it prohibits state control or direction to any person involved in production. So when you have a body where there's the state control, trying to direct any person in the production or circulation of any publication. So such as the example we saw last week of somebody trying to say, look, do not broadcast anything live, or for that matter, you already see where the conflict with Article 34 comes, that this was not at all intended. And then it goes ahead and says freedom of establishment. Establishment means the right to establish a media house or a media platform. The state also should not control that. So the state cannot control any person, starting from maybe students who decide we want to publish a magazine. Media is not controlled. When you look at what it is said it can be controlled is the content. And that content is not to be controlled by the state. It is put in the context of the Media Council, because that's now a professional body that creates that. So the state is not given a role. It is the Media Council, which is a body constituted, maybe not just ideal in the manner in which, in my respectful view, the Constitution envisages it, but it establishes a rule where the media self-regulates. That is the essence of Article 34. You remember here, a very interesting thing here, it then goes ahead to talk about state-owned media. With regard to state-owned media, the state is now ordered, you must have state-owned media. Facilitate it, but it is the state-owned media which must be given the freedom to determine their content. Even state-owned media cannot be controlled by government or anybody. It reiterates that they must be independent, and then again in the context of impartial, because it's financed by public finances. If you read 34, is 4 clearly, 4C, it actually says it must afford all parties the opportunity to present dissenting opinions, so that even state-owned media, it is not owned by the state. The state just provides for it, but must give it the opportunity to express even dissenting opinions, which could be even these opinions criticizing that same government that is in place. That is the extent to which the Constitution went, the framers of the Constitution went to try and make sure that media is free from state or political control. 5, Article 35, 34.5, that same 34, goes ahead to say Parliament is to enact a statute to determine media standards and ensure that the regulator is free from government, political, or commercial influence. It talks about government specifically, meaning all arms of it, needless to say, then political. So aside from government, it like rehashes it and says, we do not want any political influence or commercial influence on media. Again, the regulator must be free of all of these things. So if you read this, it's then creating in this context, having talked about what it creates with regard to freedom of expression, the freedom of conscience and the right to express opinions and beliefs, and then the media, it is basically creating this ecosystem of freedom, okay, super protected and super insulated, yes, that might be the better term, from state interference or even involvement. And then it goes ahead now to create a right of access to information under Article 35 for the citizen. Okay, so then you can see how that interlocks. You have your conscience to express opinions, then you have a right to express them in whichever form, then you have a media that is free of state control or political control to express them, then you have your right of access to information, which should be then provided through that media, among other formats. Okay, you then go ahead and see that even with regard to Parliament, that same making body that enacts the statute that regulates the media, it is stated expressly under Article 118. This is often missed. And 2, that media shall have the right to cover parliamentary proceedings. without hindrance unless the speaker gives justifiable reason for its exclusion. So this right is further bolstered. And why is the media covering parliamentary proceedings? So that they can then provide the people with that right of access to information of what is happening in their House of Parliament under Article 35. So that ecosystem, you can see, there's no room for control by the state, by government, or by politics. And for good reason. Based on our history, they do not want, there is no opportunity for censorship by the state or room for it by the state within that. Leo, let's go to the next slide. And why? Why does it do that? Why is our constitution doing that? I am saying that at the time the constitution was doing that, it takes it from the theoretical understanding of what the freedom of the media serves, the purpose that it serves. The constitution does not say it, but you can tell from the ring fencing that it's done that it is trying to send a message that, as was sent in Snyder versus Phelps, this is a US Supreme Court. It's probably the best way I can put it that explains this. It's a, for those who know, it's called the Westboro case. This is a case by a church. It was a Christian religious church in the United States, which took umbrage at the way social circumstances existed in the United States. Specifically, it was particularly opposed to the wars in Iraq and Afghanistan, and generally to the rights or the movement for the gays and lesbians. And so what they did was that they took it for themselves that whenever there was a funeral of a soldier who had died specifically in those two wars, they took it upon themselves to go there and to protest and picket at funerals. Would you imagine? And they were sued. The leader of this church was sued because this was causing, as you'd imagine, a lot of embarrassment, sometimes even heartache, and sometimes even emotional turmoil to the families of these soldiers. So when they were sued, they contended that no, for us, we consider it our right to express ourselves with regard to how our government is run and how public affairs are managed in this country. So we will not stop doing this. And it went to the Supreme Court. The Supreme Court then said, agreeing with the church, actually saying, yes, as hurtful as this might be, speech on matters of national concern is at the heart of First Amendment protection. First Amendment, as you know, is the equivalent of our Article 33 and 34, freedom of speech and of the media. The First Amendment reflects a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. Debate on public issues should be uninhibited, robust, and wide open. What is this? That is, we debate things in exercise of our freedom of speech and the right to hold opinions, and then it's wide open and it's uninhibited through the media platform that provides it. And they say that is because speech concerning public affairs is more than self-expression. That's the important thing. They're creating that distinction between expression and the media. It is the essence of self-government. They're basically saying that in a republic like Kenya is, speech and media cannot be hindered. And here you could tell the question of the speech was that they had sometimes very rude placards at funerals, which people found very upsetting. Imagine if you're burying your loved one and somebody has rude things about gay people and all those kind of things for a soldier who's died in war. But the court held you have to live with it. That is the price we have to pay to create an ecosystem of exchanging ideas. And that they said, thus, free speech and freedom of the media provide the bedrock of the information age. Its value, what value does it provide to the society? We've seen that it provides that sense, it provides the platform, and it's at the highest level of protection that can be given to free speech when we're discussing public issues. And public issues will only be discussed, or not only, the best forum for discussing public issues is through the media that is as widely as possible and unrestrained. And it bolsters the right to expression of opinions on governance, and particularly when you're talking about governance. Now, that was the United States. This is a common law decision Goldsmith versus Boyle. Goldsmith was was the leader of a party who sued for libel because his party had been criticized and whatever. And the court denied the claim. And they said that because the principle in a free and democratic society, it was contrary to the public interest to permit those who hold office in government or responsible for public administration to sue in defamation by a political party, putting itself forward for office or to government. They're saying specifically these freedoms exist so that we can target government with them, people in public offices. And therefore, they're basically saying the media will not exist to make people in office happy. Their existence will not make us happy. Essentially just reiterating what was in Snyder, saying it will not make us happy. They may even be unfair, but we will not be allowed to step there. That free speech must be exercised as a right in itself, complete and for its own purpose. Okay, because they're saying that the mere threat of a civil action is enough to have a chilling effect, stopping the creation of certain materials that would otherwise be published. So they're saying media needs to be free and assured that whatever they say will not come back to haunt them, especially regarding public affairs, which the people ought to know. And another example that we need to talk about is then people say, but what if they don't tell the truth, or if their opinions are upsetting or untrue? Is in the United States, there's something called stolen valor. This is a law that was passed to prevent, they really protect their veterans. They have a lot of respect for people who served their country in war as soldiers. So they consider it a great thing in your CV to say that I've been to war, I have served my country in war. So there are people who then lie, either get jobs or get favors here and there by pretending that they are veterans, that they fought a war. So a law was passed to prohibit this and actually make it an offense, that if you claim to be a soldier and you've never served in the United States military, you will be charged with an offense. So this man had lied to somebody that he was a soldier. It was found out and he was charged. And the court said, we reject the claim, saying that just because something is wrong or untrue deprives the speech of the constitutional protection. The guy said, I have a right to say that I am a general, or that I consider myself a general, or that I have served. Okay, and they said this is one of the costs of the First Amendment. That is free speech rights. It includes the speech which we detest, as well as that which we embrace. Okay, so they're saying falsehood alone, or statement being detestful to us, is not justification for making it a crime or preventing it from being said. And they said here, once again, reiterating the role of the media as the platform for exchange of ideas. They said some false statements are inevitable in a free society. And they said the remedy for false speech is truth. Basically saying it is through debate that a Republican nation will advance itself. Okay, so that in Kenya, this was taken that you can see the case of Jacqueline Okuta. There used to be an offense called criminal libel under our penal code. It still is there. It was declared unconstitutional when it was challenged. Said, where if I said something against you, instead of suing for damages, you could go to court and I'd be charged and I'd be liable to imprisonment for, I think, 3 years. But the court held it's unconstitutional. Falsehood alone, go and recover your damages. But we cannot chill free speech and freedom of the media by criminalizing speech. Yes, next slide, will you? This Kwame was going to talk about, is going to talk about, so maybe I could have ended here, but let me just say something else. You know that there is a direct link for those who are arguing about the value of freedom of the media and of speech, that what is it in trying to create that distinction between civil and political and economic and social rights. That link has been demolished, as Leo said, and by several instances. You gave the other one. The other one is the Global Expression Report, which ranks freedom of speech across 25 different matrices in countries. And one thing comes out, that the higher a country is with its freedom of expression on that whatever, it matches also directly and proportionately with its human development indices. So the bundle of rights that facilitate the public right to information of all categories So what does freedom of speech provide for us and that? So it gives us an example, something like prices of goods and services. If you want to know what, for instance, the share of Nation Media Group sold for yesterday, the place to find it is in the newspaper. The prices of goods and services in itself is an economic good for you in knowledge and as an economic impact, because it helps determine demand, it helps determine supply. The economists can explain that better than I do. And that is why you realize, and I would say there's a constitutional realization of that, for instance, which is why, for instance, there's the offense of insider trading, because it realizes that information can have economic value. Insider trading, as you know, is the offense that prohibits somebody from using information regarding a listed company to trade in the shares of that company, if that information is not yet available widely to all the shareholders. As you'd see, for instance, we have one instance where a former CEO of Kenya Commercial Bank was charged. He was not acquitted, but it's an example that shows that this is an offense that is taken seriously. And it exists for that reason, saying, look, the law recognizes that some information could have economic impact, and that therefore it needs to be provided to everybody equally for their well-being, so that others don't take advantage of that information at their expense. This is why then the media is able to provide commentary on other people. There are certain aberrations, for example, that one I put in red just so that we can see. The Statistics Act of Tanzania, for instance, we've had instances where the Tanzanian government says that some statistics cannot be published regarding the country's economic performance without the permission of, what do they call him? I think the Statistics General, Statistician General, the equivalent to the Director General of their institute, their body of statistics. It's an aberration, you can see. But really, if that kind of act were to be in Kenya, I do not think it would pass muster under Article 34. So they say that, in other words, freedom of media and speech play within the marketplaces, whether of economic, social, or political information. Just saying that rights have been merged, there's no category, and they all provide economic value together. Yes, next one. Things I wanted to just talk about, they may not be whatever, but we have contemporary challenges to media freedom and independence. So we have these outdated and problematic laws. You see, when we passed our constitution, there are certain laws that remained that nobody thought about, as thought about. We have a penal code that penalizes publication of untrue statements, that if you publish an untrue statement to somebody, and particularly to a public official, then you could be held responsible for that as a crime. Defamation of a foreign prince. You can see where this is from, to shield politicians and their equivalents, heads of states and political leaders, from criticism. So that if you criticize, for instance, if today under this law, somebody was to write a letter criticizing the Crown Prince or the King of Morocco or the Emirates, you can be charged under this. Or publication of information which undermines the authority of a public officer. Basically, constraining criticism of a public official. But this, I need to say, has been declared unconstitutional, Section 132 of the Penal Code. And then we have the elephant in the room as we speak, the one that is amenable to the greatest misuse. Computer Misuse and Cybercrimes Act, the offense of false publications and publication of false information, sections 22 and 33. These two have been declared unconstitutional several times, but they remain on our books, and somebody continues to whatever them. So that's why I asked the question, may falsehood in speech be criminalized? The decision said, unless you derive something, unless it is fraud for which there's a civil action resolution, this ought not to be. Even simply that speech is hurtful is not a reason for it to be declared unconstitutional. 34, 35, and Articles 32 take care of that, read together. Next one, Leo. So in conclusion, I just cite Amartya Sen. You people would probably understand him better than me. In his book, Development as Freedom, he centers on the idea that freedom is both the primary end and the principal means of development. So economic freedom, which will give us economic development, the connection is clear. And he just said that economic development is not just about increasing wealth, but about expanding people's freedoms to make choices and live lives they have reason to value. So you can see what the wisdom in it is. It comes from an understanding that the freer society is, the better it will be for its citizens. And therefore, that attempt at creating a chasm between political rights and economic development or well-being of the people is not one that is borne by history or even the realities of the present day. The connection is real. And that's why the challenges lie in the practice of individuals and regulators in failing to appreciate the true essence and scope of these rights, and that even then their benefit for the country, I do not think is something that somebody can argue about. Thank you.
Thanks a lot, Seku, for that very comprehensive and informative presentation. It leads us seamlessly to our next presentation, which will be basically having had the foundations of the two freedoms and why we consider them economic freedoms, then had Seku's presentation on the legal foundations and the limits of state power around the two freedoms. We now go to linking these two to economic progress. And we'd like to hear your views, Mr. Kwame Owino. Kwame is the CEO of the IEA, and he'll make the next presentation. So please, Kwame, go ahead.
Yes, so we've heard about that. I mean, my question is really simple. It's about how do you justify or what freedom of expression and freedom of the media, and what are their contributions to economic progress? And the way to think about it is that, the way to think about this is that freedom of the media is basically, so the media is a channel, the information is the commodity. Both of them, obviously, freedom on both sides actually provides for an opportunity for markets to form. You know that the basic analysis of markets was one on the supply side and one on the demand side. And here I make no distinction between the supply and demand, because one person's consumption or demand is actually the possibility for another person to repackage and to supply. So the first reason for economic progress is that, look, a guy called Adam Smith mentioned something that is a truth, I think less recognized, which is that basically the division of labor, the extent of the market, in other words, the size of the market, and as economists, we read bigger market sizes or the sizes of our markets, the sizes of markets in societies correspond with the prosperity of that society. And that prosperity is therefore what the question before us is about what leads to economic progress. The freedom of the division of the extent of the market, in other words, the size and prosperity of a society, will be determined by the division of labor within that society. In other words, the extent of specialization. So if you have freedom, you can tell that the first thing that it does, it will allow for people to split, size, create those markets on both the content side, which is basically the information itself, and on the media side, which is basically the content or the channel through which that is done. So the more you have specialization in that places, the more progress you do. And that's why there's no doubt at all that the higher the societies you go from, them, probably some people who think differently, but perhaps they should be more acquainted with how economists think, which is the higher the incomes that societies have, in most cases, you'll find there's more media in those places. There are more channels, both channels and information, because information actually wants to be free. That's my own rhetorical question. So the first is, you can see that if you're going to create specializations on both sides, then there's the possibility of monetizing both sides. And when you monetize both sides, you're creating prosperity by allowing for people to specialize to create one or the other. So for instance, in Kenya, we have all manner of forms of information, or forms of media. So people talk of social media as one form of aggregating, dispersing news, and even consuming it as well. So on that same platform, you have both the supply and demand side. And the more expanded it is, the possibilities of prosperity. And there are certain people for whom media, whichever form, print, electronic, social, whatever others be out there that I haven't recognized, represent not entertainment, but for them it represents opportunities to actually supply a service which they are monetized and for which income or economic progress could issue. So that's the first one. The second reason why I think media is an essential thing is, look, in a market economy, and market economies are without doubt more successful than economies that don't arrange around markets. So we know as economists that markets are a very good way to arrange economic activity. Markets depend on one thing. Markets are fertile with information. And the more information is available in the market. So for instance, price is a market. Price is information. Packed within price is information about how much you may pay for it. So if something costs a certain number of dollars, shillings, or whatever currency you use, it's telling you what you will forego, right, to buy that. That's information as well. And it therefore allows one to make a critical decision about whether this is the best way to use the value of your effort, to use the value of the resources you have, and whether you can get an alternative. And therefore, because markets are developed on the basis of information, including the supply side, whoever is supplying it knows how to make sure that it reaches a market or it reaches people who might get it. So that would be in the form of advertisement, for instance. So advertisement, all these forms of markets are connected, and they would not operate without information being made available. And that's why we find historically societies in the last century, especially, societies went bifurcated. So you had socialist economies that were very, very heavily controlled, in which there was no difference between government and markets. And then we had the other ones, which are more open. You can argue your moral imperatives whichever way. There's no doubt which societies were more prosperous. So here again is evidence, empirical, within our lifetimes, at least for the lifetimes of people like myself, which showed us that societies that allow for flourishing of information, economic information, and any other would come down. The third question I would say, or rather that markets are fertile with information, and the more information that they have, the more prosperous they will be, because people have choices. It expands people's choices. It allows people to make more informed decisions around economic decisions, basically. So for instance, even jobs are markets. So the price which you pay for a job is your income. If you're able to compare across incomes, you know which one is most suited for your choices. So we have come to the point that information is a commodity. It could be monetized. The channel is also a commodity which could be monetized. Our second point is that markets operate best under under conditions in which information can travel or information could be pervaded. And that obviously requires specialization on both the side of the producer and also through the price of the person who provides the channel to connect, so that markets can be completed for. The third is the most innovative societies depend on information. And information that requires one piece of information to be fitted together with another to generate a more complex or a better product. I give the example. For instance, one of the most successful digital companies, I mentioned this just because it's the other, in the world is a company called, right? You all know it, right? The Apple Corporation. And this corporation specifically provides a whole lot of services. So let's take the most basic one, which is perhaps the facility you're using to read the computer or some digital enterprise. Now, a chip or whatever it is that makes it into that is the result of some information that a physicist developed or a researcher developed in a certain lab, in a university perhaps, or in certain public places. This was published in a journal, in an article, somebody else, by seeing that information, because that information is available in various media, interprets it as the possibility of developing a business product. So innovation, product information, process information, which then brings to us, or at least brings to a majority of people who use this product, that product is in itself is the convergence of information with markets, with specializations and all that. So innovation itself is heavily dependent on the freedom for information to travel. If that information was locked in specific silos and was not allowed to leak, for instance, then obviously the pace of human development and technology would be far, far slower. And therefore progress would be much, much slower. The final one is basically that I'm arguing here that constitutional protections for expression and media, so for the content together with the channel, are not just moral or political as you've had, but they're also economic imperatives. in the way that I've argued. One of the ways in which the economic imperatives is the ability to purvey information, again, speaking about the channel and speaking about the content itself, is useful for democratic practice to occur. Why? Because a fertility of information allows us to have healthy skepticism of state control. And state-controlled systems tend to actually be systems that block out information. So here I'm talking about the political side. And so a state that is exposed to less and less information, whichever way, is a state that is less likely to be making progress in terms of allowing citizens freedoms, some of the freedoms of which we are debating here, but there are also states that are less likely to prosper. Another example that we can have, North and South Korea, both the same people, 98% same genetic material. I mean, largely the same genetic material, very locked, and for a long time there was no. And as soon as one state decides, for whatever reasons, more open, the other is less open, we can tell what the economics results are here. So as I'm concluding, I'm saying that 4 questions that I've talked about, we've talked about the moral imperative, we've talked about the need for skepticism about state control, because state control reduces human progress. As a matter of fact, both in political markets, in social markets, and in economic markets. Innovation occurs best when these freedoms are available, and information itself is a commodity that can be channeled because of specialization and allowed to create value along the line. So thanks a lot.
Thanks. Thanks a lot, Kwame. So we've come to the end of our 3 main presentations, and all the speakers have articulated or spoken very eloquently around the rights, the foundations, the limitations, and also the economic value of allowing or advancing the enjoyment of the 2 rights. So some of the main takeaways, there have been very many useful nuggets from the discussion here today, but one of the things that I've had emphasized is obviously that media freedom and the operations of the media should not in any way be subject to any interference or direction of the state. I think CoK made that point very eloquently. Information has economic value. I think that has been a common thread through the 3 presentations. And the last and most important, at least for me, is that free speech includes even hurtful speech. And basically, in the context of what has been happening, there's jurisprudence to show it that has been demonstrated here. And basically, that sums up our 3 presentations. So that stated, I'd like now to go to plenary, and I'll basically now allow anyone who has a question or who would like to express their views on what has been said today. If you agree, disagree, if you have any questions that you'd like to be addressed by any of our speakers, I'd like to give you the opportunity to ask. Please raise your hand and I will allow you to ask or to make your contribution to the discussion. I'm looking at the chat box and I do not see any questions yet. So if anyone would like to, yes, I see a hand. So Kisimbi Thomas, please unmute yourself. Let us hear your question and to whom you'll be addressing it.
I think this will most likely. Hi everyone, my name is Kisimbi. I'm here in Nairobi temporarily for now, and then really interesting conversation. So I'm really grateful for this series, and then also I mean like just the various webinars that you organize on this is actually really amazing. So keep up the good work. So the question that I was probably would ask for Seko would be, so thinking about unbridled speech, right? So the same Supreme Court in the US also kind of said is that when you shout fire in a crowded movie theater, that is not protected under speech. So at what point, so where do we kind of draw the boundaries of what is accepted and where kind of almost what we would call responsibility lies, when especially speech is particularly harmful or misinforming, or in ways that don't advance, kind of the welfare of everyone, or not welfare maximizing, so to speak.
Great. Thanks, Kisimbi. We've noted your question. There's another hand by Gitonga C. Gitonga, please unmute yourself and let's hear your question.
Thank you, Ms. Jacqueline, and thank you for the talk. My question is in the context of what is going on right now when we are trying to use our voices or speak and mobilize against the ills we are seeing in society. So, in a sociological context, or if say this was when we didn't have our laws, or in the context of say the War of Nations, where you're allowed to use violence or cause anarchy. So, at what point does free speech, much as we have laws and we have a framework of engagement, but if we are speaking freely and we are not being heard or we are not being listened to, can we escalate this speech to so-called to the levels of, let me call it, incitement or hate speech, notwithstanding that might fall afoul of the law, but I think the pragmatist will say an unjust law is not a law. So in the context of, or against the backdrop of what is happening right now, where we have where politicians basically, and this is basically politicians and public servants, are not listening, and then they're still imposing and using these laws to tamper down these discussions. At what point can we push the boundaries of what is acceptable, and just to make the point that we want to reset and we want to be heard. So can we burn down a building just to be heard? And would that be, of course it would be illegal under the laws, but would it be defensible, say constitutionally? Thank you.
Thanks, Gitonga. We've had your question. Let's see if anyone else would like to ask a question in this first round. Please raise your hand and I will. Yes, Marcus, I see your hand is up. Please unmute yourself and let's hear you.
Thank you very much. My name is Marcus. I hope you can hear me.
Yes, we can hear you.
My name is Marcus. I hope you can hear me.
Yes, we can hear you now.
I love Gitonga's question because it basically, as I would see it, basically asks ourselves whether we want to protect the very freedom we are talking about right now. Yes, we can talk about media freedoms, but can we actually enforce it? And what happens when we try to enforce it? Through protests, as you can see, or can we actually use other ways to enforce that freedom? Because it is not enough to just say that we have freedoms. Yes, the Constitution says that, but do the people themselves have the power to enforce it? And as we have seen, maybe for the last 1 year, we do not have that power to enforce that freedom. So as we are speaking about this freedom to speak, to talk about our rights, talk about accountability, the truth remains that in Kenya and in most African countries, there is no freedom to actually, there is no freedom, because it's not just enough to say that we have freedom. There is no power to enforce it. And as we talk about this, can we think of ways that we can give the people, the sovereign people, the power to enforce that freedom? I will give you a simple joke or simple example. It is usually said in the US that the 4 founding fathers, the First Amendment they put down was they gave the people the freedom. But the Second Amendment, for those who knows those amendments, the Constitution of the US, was the right to bear arms so that if somebody dares take away your freedom as a people, you can actually protect themselves. They can actually protect themselves and their freedoms. I don't ask for right to bear arms for Kenyan citizens. It can be a bit chaotic, but maybe there are other ways in which you can give the power to the citizens to actually protect the freedoms. Can we think about that too? This is just a general question to everybody listening.
Thanks. Thanks a lot, Marcus. I think we'll take that first round, and let me add what is on the chat box. So thank you to Mr. Wino. What is your view on the freedom of speech by individuals, not media? So basically using online platforms such as Facebook, etc. So yes, I'll request you, Seku, to go first because most of the questions are on the legal side. If you'd like any clarification on any of the questions, you can let me know.
Okay. Yeah, let me start with the last one, where you say, what is my view on individuals' freedom of speech and not media? And that's why I say these are two different rights. The Constitution does not create a hierarchy of citizenry. So everybody has their rights fully as granted in the Constitution and in the Bill of Rights. So the freedom that you have is not limited. It is to the fullest extent as that in under 34, because if you realize actually 34 makes reference to 33, which is where the freedom of speech exists. So those rights are full in any sense. The media does not have a right higher than anybody in terms of the freedoms that are available to it in speech. Okay. There's a question asked by Kisimbi and Gitonga. They're more or less tied, but Kisimbi is asking something about the limits to freedom of speech, where he says what is acceptable, and he cites the example of Oliver Wendell Holmes saying the freedom of speech does not include the right to shout fire in an auditorium, and that already is actually covered. It's not an issue in whatever. Article 33 and 34, if you read them, and actually 33.2 is very clear. It says that freedom of speech there shall not provide cover or immunity for incitement to violence, hate speech, or vilification of others. In short, it's talking about codifying what Oliver Wendell Holmes was saying, that you don't have a right to shout fire in an auditorium. If, as a result of that speech, there is going to be a direct physical harm on a third party. If you look at physical violence, incitement to violence, vilification with a view to them, and hate speech. Hate speech generally is specifically speech that targets certain people for them to be harmed physically. So that's covered. Our constitution perceives that and acknowledges that. So yes, we agree, we can say anything, but do not say that which is going to cause a third party to be harmed as a result of your speech. That cannot be covered. And so it's clear. Marcus is talking about can we use other ways, whatever. The Constitution, let's be clear. I do not know that we can say, as he's saying, that there's no way to enforce it, the freedoms. The courts are there. Within hours, and to give example, within hours of the purported ban on live broadcasts, the High Court had issued an order quashing it. So that's how rights are enforced. Rights are enforced within the constitutional spectrum. Let us remember that there are some arguments that we cannot make ourselves as the people, notwithstanding our sovereignty, is because our constitution is not a legislated constitution. Our constitution was promulgated following a referendum. So it's basically, this is technically, if you can talk about legislation, you say this is a constitution the people of Kenya gave themselves. It was not given to us by a parliament, or it was not given to us by an order in council or a privy council, the way our independence constitution came to us. This is a constitution we legislated ourselves. And by it, that's why to that extent, it's called a social contract. We agreed to abide by it. And we said, if any of us is not living by it, we will take you to court and force you to comply. So I am not sure we can say that it cannot be enforced. It envisages how it will be enforced. And even exercising rights is one of the ways of enforcing it. Protesting, picketing, all those rights that are given, speaking, critiquing our enforcement of the rights, where we are saying we know that these things should be done, certain things have not been done, and we want particular change, but it must be within that constitutional order. Let us remember that that's the constitution we gave ourselves, and by giving it to ourselves, we were saying that we will all live within it. So yes, even as we advocate change, we might be even advocating change, and let's be careful, what are we advocating? Is it a change of the constitution, or we want to advocate that everybody within the constitutional rubric complies with it? And either of those must be done within that whole constitutional ecosystem. It does not permit us to do anything outside the constitution. You remember, there's an article specifically, I think it's Article 2, that says that government cannot be formed in any way other than in accordance with that constitution. So it sets itself, that's our essentially our Grundnorm, and it's our cornerstone of governance. So that is what we have to understand, that yes, it gives us those opportunities, that those rights to picket, those rights to demonstrate, those rights of freedoms, our rights to information, our rights to hold opinions, they are all within the constitution, and that we just enforce them. And not all constitutional rights are enforced necessarily through just exercising them. You've already enforced your right. Criticizing a regime or criticizing anything, and that criticism is not just about the regime or political power. We even criticize corporations, we even criticize other citizens. That is what the right is, and it's how we exercise those rights and enforce them. So it is just that whichever way we want to do it, the constitution is binding us to make sure that we act legally within its four corners, as it were. I don't know if I've missed anything. No. So I think I've answered all of them.
Yes, I think you have. I don't know if Leo and Kwame would like to add anything to that.
Yeah, can
yes,
I add something?
Yes, Kwame.
Okay.
Yes, please.
Okay, so Kisimbi asked a question. Yes, I think this fine a crowded theater is used inappropriately. I mean, to tell us where there should be limits to what people say, and I mean, I have a different view with the idea that so for instance, I think that the freedom of speech should distinguish between what you say in which what one says in spaces, whether that space is private or public. So if one person owned a theater, my view is that your rights to property would allow you also to make any kind of speech within your property. Now, that's not necessarily something that the lawyers have had before will agree with, but my view is that regardless, if you go to a theater and it is not a public space, then you should be allowed to actually make any kind of speech that you would, provided those who are in attendance would allow you to. And so we need to distinguish areas in which government should control what we say away from areas in which government could not. So for instance, if it's in a public place, certainly there might be a requirement to have to adhere to what other people are. Because when you're going to a private place, you have chosen to come to the theater, which is owned by a certain person, and they do not owe you the responsibility, I don't think, constitutionally at least, the responsibility to film or to have speech that meets your moral sensibilities. Because they too have their... So that distinction perhaps is one that has not been made in Kenya that we need to make. That's one. The second thing that worries me with hate speech, and I'm completely conscious, and I refer to the fact that the Constitution specifically prohibits it. The problem with hate speech is we have to be careful because we now have hate speech used or weaponized as a way of restricting speech. And one of the things that I have a problem with is I would think that we have to be careful not to equate speech, however virulent, with violence. Any form of violence should completely be unacceptable. But I think speech, and whether there's any such thing as violent speech, is something that I actually think is itself questionable, because that requires psychological interpretation, not only of, I mean, instead of a legal interpretation, you're assessing whether somebody intended to harm another when they say, for instance, this and that. And the final one is this about the question of speech. And I know whenever people argue about how we demarcate what is free speech, they're talking about what is safe speech and stuff like that. I have a problem with that because I think the public sector, and especially people in government, infantilize citizens by claiming that speech that they find hurtful should not be expressed because it will hurt somebody else's opinion. And I don't know that anywhere in the Constitution there's a requirement or specific requirement for us not to say things that are hurtful. Let me bring it now because my work was to talk about the commercial side. You see, the most dramatic adverts I've ever seen is one that's been circulating here, in which one car company actually takes another car, right? Blots out the logo and then races it against the other and shows how inferior this other one is. Now, if you're the engineers for car one, you should feel very hurt, maybe even hated by your competitors. Is that necessarily something that's bad in terms of commercial beauty? I don't think it is. But if it were to be in a political sense, remember, even cars, I mean, if you're a person who owns vehicles, I don't, but those who own vehicles know that vehicle owners and the brands are very tribal. If you go to certain hotels in Nairobi, they have certain spaces on a certain day when the people who drive a certain make of car meet to chat about themselves. And they will not allow a competing brand to be meeting in the same place, otherwise they move. That's very tribal as well. And so they'll be their sensibilities would be very hurt if the other guys came and said how useless their side impact protection systems or whether their new chips would be. So I'm just trying to say that I think we shouldn't infantilize people by having a state officer or a judge make a decision that this is hurtful, and because it is hurtful, it qualifies as hate speech, and because it qualifies as hate speech, we should truncate speech. Even if, of course, there are people who say that you can have magazines and people using hatred to commercialize and monetize it. It's just bad manners, but so be it. I mean, there are lots of other commercial materials that are sold to us that are completely junk. I mean, nobody should spend their money on. Actually, we should spend money to ensure that they're not produced. Thank you.
Thanks. Thanks, Kwame. Yes, Leo.
Yes. So I just wanted to add, the three questions have one running theme, which is we need to remember that government by its design actually has monopoly of violence in many ways, through police, through many other mechanisms. And they make decisions, including our Kenyans. So the big issue that as Kenyans we need to know is that to find ways in which to discipline governments or to incentivize them or disincentivize them to be able to be on the constitutional path, which is that freedom of the media and freedom of speech is important. Because once most people have taken that that process of disincentivizing government, including voting and the others, to mean that they go into extra into other mechanisms that disenfranchises others. Because we've seen many times, especially through courts, that courts have prevailed, and that's judicial oversight. So we also need to have a crop of people in parliament that are able to provide that parliamentary oversight that actually obeys the dictums of the constitution, and even people in the executive branch. Because that delegated authority has to be exercised in a way, and that can only come through now. And this is the area that as a constitution law and economy program, we actually are fighting for how to build those inclusive institutions as those inclusive institutions that obeys these constitutional dictums. So it's important that that power of the state, we think through it, through the things that the constitution has given us. So part of it could mean that having a stronger parliament, a stronger institution of parliament, a stronger judicial oversight. It could also mean that very progressive judges who are able to view the constitution, to construe the constitution in the way as provided under Article 259, that to push that democracy and further. Thank you.
Great. Thanks, Leo. So we'll go to a second round of questions, and I think this will be our final round. So if anyone would like to ask any of our speakers any question, this is your opportunity. Please raise your hand. I'll see it. I see one already by Michael. Michael, please unmute yourself and ask your question. Did that hand disappear? Okay, Emmanuel, I see your hand is up. Please, let's hear your question.
Yes. So thank you. I was thinking the other day that about 12 months ago, when the public sort of rallied and chased down, hounded, sometimes harassed, but in essence, followed up with their legislators on questions concerning the finance bill and then other frustrations surrounding governance, that in some way, spontaneously, the public had actually arrived at what I think should be the norm in terms of keeping in touch with the legislators and sort of exercising that freedom, and that with it, I thought with it comes many the exercise and the maintenance and the expansion of all these other rights, because you're making sure that your representative does his job. But then in my own observation, that sort of enforcement, that flavor of enforcement, sort of tapered off, and people don't seem as interested in doing that anymore. So I thought I wanted to get perhaps some commentary on that. What you think about that? Because I thought that that's where we need to be going in as a country.
Thanks, Emmanuel, for your question. Moses, I see your hand is up. Please also unmute yourself and ask your question. Moses, do you have a question? Okay, I don't know if Moses is okay attempting to speak, but I think in the meantime, does anyone else?
Can you hear me?
Yes, I can hear you now.
I was saying on the Bill of Rights, Chapter 4 of the Constitution on access to information, we have the right to access information held by the state, but we have consistently seen some of the information, especially on trade treaties and investment, withheld from the public. Given that, what should be our approach to ensure that the state actually releases that information? Thank you.
All right, thanks, Moses. Does anyone else have a question? Because I think this is the last opportunity that I will allow. If you do, please raise your hand and let's hear your. So in the interest of time, because I don't see any other hand, I also have just two very brief ones that I'd like addressed by CoK and Kwame. So CoK, there was something in your presentation around the problematic legislation that currently exists. And I was wondering if you might be aware of any steps either by a media house, the Media Council, the Kenya Editors Guild, or any parties. Might you be aware of any steps that have been taken either to push for their repeal or the reform of these laws? And then for Kwame, I was also curious, who do you think bears the biggest costs of information censorship? So the economic costs, do you think there's a hierarchy in terms of who bears the biggest costs? For instance, when we have a ban like we saw, or a purported ban like we saw from the authority last week, who do you think, so basically your views around that. So because I don't see any other hand as you respond to the other question, I'd like to start with, actually, let me start with the CoK.
Yes. Can you hear me?
Yes, we
Okay.
can hear you.
Yes.
Okay. I didn't get Emmanuel's question. I only got this one from Moses, where he's asking where government refuses to release information, how do you get it done? There are enforcement mechanisms. The enforcement mechanisms and the enforcement mechanisms are the same ones that I said are available for you in the Constitution. If the government doesn't release that information, you make a formal request. There's a law on it, on freedom of information legislation, which gives you a process. You make the formal request. If they decline, you can either go to the ombudsman, then the National Commission on Administrative Justice. They should be able to then comply. If you still don't get your remedy there, then you can go to court to seek an order compelling them to do that. And it's been done a number of times and they've been able to release it. The other alternative also is to petition Parliament. And then Parliament can order the executive to provide that information to you because they have that supervisory role over the executive. So there are mechanisms of doing it within the law. The other one you've told me is whether we've applied for repeal. Yes, I have myself written to both the Director of Public Prosecutions and told him that following this thing, he should instruct the police to stop bringing in these charges. Secondly, I have written to Parliament also and told them, look, these laws have been declared unconstitutional. Do your best and either repeal that act or amend them by deleting those specifically unconstitutional acts. That's the most I can do within the constitutional frame that I live in. Yeah. So
Thank
we
you,
have done
thanks.
something. I can say that. I myself have written about to both the Director of Public Prosecutions because he must authorize every prosecution. So just as a question of making him aware, tell them, just make the police aware that you will not pursue these charges. I don't know if that has been done, but then I've also gone to Parliament to just repeal it so that we clean that up.
Thanks a lot. Kwame?
Okay. Well, this question has come from Michael on the chat, and that's probably for CoK, but I'll go for the question you asked me and then make my concluding remarks. Who bears the biggest cost for information censorship? Well, I think the cost might depend on the issue, right? If the information censorship is a question of it's commercial, for instance, then it is possible that the competitors or people who wish to use that information for the purposes of that. So, for instance, we have information on certain operations that, say, the central bank does or any other public bodies who themselves also actually participate in markets. If, for instance, you cannot see some of the data that they use, which they consider, or rather if the state considers certain public information as proprietary, because that's what censorship means. When censorship is applied, it means the state is taking custody of private public information and making privatizing it, for example, within a state department. So that definitely will hurt the opportunity for markets to form, because markets tend to form, as I said, price information is important and spontaneous order. So if certain information were available, it is possible for people to interpret that information to provide services and goods around it. So that would be, as what you saw last week, I mean, it could be as well, because knowing where protests are taking place might be useful, I say this advisedly, for a seller who's prepared to take risks to know where to sell masks, where to sell water, even where to a border guy could go and use help to evacuate people, right? Including an ambulance. So they are both economic, social, as you say, even health costs that obtain from government trying to freeze information such as what we saw last week. Censorship is costly. And that's part of the reason why it should always be considered it should not be considered the norm. It should actually be the exception rather than the rule. Thanks.
All right. As we come to the end of this discussion, I see two comments in the chat box. So Emmanuel says, sorry, my question was poorly worded. Here it is. Is the practice of salimaring legislators a good way to enforce the freedom of speech? Should we encourage more of it? And And then Michael asks, my question is this: if we contrast how the state limits other rights versus how it limits the freedom of the media, there's a clear difference. For instance, when the state needs to limit your right to privacy, say by searching someone's premises, it has to first get a search warrant, essentially justifying being allowed to limit a right before they violate someone's privacy. However, with the freedom of the media, the state often first limits the media, who then have to go to court to quash the limitations. So my question is this: should the state be required prior to issuing media bans to seek warrants permission from court? So before Seku answers that question, I think because Kwame has already made his closing remarks, I'll ask Leo if you have any feedback on any of these questions or a response to Emmanuel, although I think Seku already answered it. But let's hear your thoughts and your closing remarks. Leo?
Yes. So in conclusion, I think to rephrase Emmanuel's question, which is, it's a good practice. Constituents need to speak to their legislators and speak to them about policy questions that they need to, and that is accepted convention. And I don't think that there'll be a practice that there's something that bars it in the constitution, in the constitution. In fact, it's a good practice because it shows the pressure on issues on the attention that they need to give to those specific policy questions. So in conclusion, for us, I think, and Jackie would add to this about the Constitutional Law and Economy Program, we intend to hold more of these conversations, especially on topical law and economic questions. And we'll be hosting another legal expert to discuss the policy issues related to Owino Uru case. For all those who remember the lead poisoning case in Mombasa. And that it's a good thing to realize constitutional protections and to settle questions, because we wanted our audience to understand that there is nothing that bars that in the constitution that gives government unlimited power over freedom of expression and freedom of. In fact, governments are poor even when it comes to setting objectives or what should be expressed and what. So, and we wanted to settle that debate so that our audience and the people in the call would be able to understand. So thank you so much. And Jackie, back to you.
Yes, thanks, Leo. And I agree that it's actually good practice speaking to your legislators. Even recently, I think 2 or 3 days ago, I saw President Obama, former President Obama, actually urging Americans to pick up their phones and call their legislators and ask them to have a certain response to an important law, because they are your representatives. They are our representatives to make a certain decision in a certain way. So I think that should be the practice even here. And so, and thanks, Noah. I see you've posted a section of the Access to Information Act. So this is in response to what Moses had asked earlier with regards to the procedure for accessing information. It's problematic, although the mechanisms are there in law and in the Constitution, as Seku said, but basically the remedies are there in the law for how to do that. So as we conclude, I'll ask you, Seku, to please respond to that last question by Michael and give us your closing remarks.
Thank you, Jackie. Can you hear me?
Yes, I can hear you.
Okay. But before I answer Michael's question, let me just add on to what you've said about it. It's actually a constitutional right. That's where the constitutional right to petition public authorities comes from. So you can send them those petitions, whether by phone, by letters to the newspapers, and etc., or even phone calls to themselves. That's a constitutional right. The right to petition public authorities. It's a constitutional right, so there's nothing wrong with it. Okay. Now, the one you're asking about, why government does that and why it can't go to court instead of this. You see, when it comes to searching your house with regard to a criminal offense, that right to privacy, there's a permitted limitation with that, and that's why they're required to come to court and obtain a warrant. The reason with regard to the media they will not do it is because they don't have that power. So they, even if they were to go to court, it's unlikely that a court would allow them, in light of our reading of Articles 34, 35, and 32 and 33, to then come and shut down the media house, which is why then they do it and they cite phony laws which cannot be sustained. And it explains why when the LSK made this challenge, the court lifted those directives immediately. So those should be my answers. Thank you very much, IEA, and thank you very much, everybody who's listening. This is a conversation that is worth pursuing. My only suggestion will be it helps for you to read the Constitution, try and familiarize yourself with it, look at it in comparative context, what is happening elsewhere in other Republican democracies, what we aspire to, and all the best, everybody.
Thank you. Thanks a lot, Seku. At this point, I'd like to bring this to a close. We appreciate very sincerely the participation of all our speakers, especially Seku, who is obviously our external guest today. So thanks a lot for taking time to share your thoughts and explain to us the issues that we were trying to, the issues around these two rights today. Thanks to Leo and Kwame for also enriching this discussion. So I'd also like to thank all the participants